Okay, so I want you to listen to the sound in your mind for just a second.
All right, I'm listening.
Think about that heavy, metallic clack, clack, clack sound of a really old manual typewriter.
Oh, yeah, like an old Underwood or something.
Exactly. So picture this. It is 1934. You are in Washington, D.C., and you are in this room with a bunch of lawmakers.
Probably a very smoke-filled room.
Oh, absolutely thick with cigar smoke. And, the Prohibition era has basically just wrapped up, right? But the headlines in the papers are still totally dominated by mobsters.
Right, you've got Al Capone, John Dillinger, guys running around with some pretty highly destructive weapons.
Yeah, Tommy guns, automatic weapons, bank robbers, just outgunning local police everywhere. So these lawmakers are sitting around this table and they are desperately trying to draft a piece of federal legislation to stop this.
And they are trying to be really precise.
Exactly. They are typing out this one single, highly specific sentence. Now, imagine walking into that room in 1934, tapping one of those guys on the shoulder, and telling him that the exact grammar of that one sentence typed 90 years ago would literally be used in 2024 to legalize incredibly advanced firearm technology.
Technology they couldn't have even dreamed of.
Not even close. We are talking about polymer, CNC machine stuff that can shoot hundreds of rounds a minute. And that is exactly our mission for this deep dive today.
It's a fascinating subject.
It really is. We are going to tear into the mechanical loopholes, the deep engineering, and the massive Supreme Court battles surrounding two very specific firearm accessories, bump stocks and force reset triggers, or FRTs.
What's really fascinating here is the historical juxtaposition. You have these lawmakers in the 30s dealing with Tommy guns, and they write down this highly rigid mechanical definition on paper.
Right.
And they weren't thinking about the 21st century at all. But that exact string of words is now acting as the ultimate legal measuring stick for modern American firearms engineering.
Which is just a brilliant example of American constitutional checks and balances at work, if you ask me. I mean, today we are unpacking a really complex legal and mechanical war.
And it really is a war over definitions.
Yeah. It's a story about how the exact microscopic mechanical definitions of gun parts actually determine the limits of federal agency power in this country. And we are going to look at the exact federal and state landscape as it stands today, right now, in August of 2026.
And something we should probably clarify early on, which might surprise a lot of people, is that the biggest victories for these devices weren't actually fought on Second Amendment grounds.
Wait, really? Because, I mean, whenever you hear about a major firearm case going to the Supreme Court, I feel like everyone instantly assumes it's a Second Amendment right to bear arms battle.
Right. It's a totally natural assumption to make. But in this case, it's actually incorrect. These were battles of statutory interpretation.
Okay, meaning what exactly?
Meaning it all came down to the precise, physical, mechanical wording of the law passed by Congress. It was about administrative law. Basically, do modern executive agencies have the power to stretch those old words to fit devices that were invented decades later?
Okay, let's unpack this. Because my goal today is to translate all of that really dense legal and engineering jargon into clear, physical realities.
Right, things people can actually picture in their heads.
Yeah, exactly. I want you, the listener, to really visualize this. Because whether you are, a firearms enthusiast prepping for your next build, or a legal scholar, or honestly just a citizen interested in how the American justice system holds federal agencies accountable, understanding these mechanics is vital.
It really touches on the foundation of how laws are made in America. Who actually has the constitutional power to change them? The executive branch or the legislative branch?
Right, separation of powers. So to understand why this is all happening now, I think we have to actually go back to that room in 1934. Let's look at the catalyst for all of this, the National Firearms Act or the NFA.
Right, 1934 NFA.
Before we get into the modern bump stock battle, we need to set the table here. Why did Congress write this law, and what exactly did they put on that paper?
Well, the NFA was the first major federal gun control initiative in the U.S. And what's interesting is it didn't outright ban machine guns.
It didn't.
No, it used the federal government's taxing power instead. So if you wanted to legally own a machine gun or a short-barreled rifle or a silencer, you had to register it with the government and pay $200 tax.
Okay, but in 1934, $200 was a massive amount of money.
Oh, absolutely. It's equivalent to thousands of dollars today. The whole goal was to make these weapons just prohibitively expensive for the average street criminal, while technically keeping them legal so they didn't run afoul of the Constitution.
Okay, that makes sense. But to tax a machine gun, They obviously had to define what that actually meant in legal terms.
Exactly. They needed a strict definition.
And this is the sentence, right? The exact string of words that causes a century of headaches. Let's hear the literal definition they typed out.
Okay, so under the 1934 NFA, a machine gun is defined as any weapon which shoots, is designed to shoot, or can be readily restored to shoot. And here is the key phrase: automatically more than one shot, without manual reloading, by a single function of the trigger.
Okay, let me repeat that. By a single function of the trigger.
That is the whole ball game right there.
So before we talk about bump stocks or these forced reset triggers, we need to do a deep dive into the internal mechanics of a standard AR-15. Because if we don't understand how a normal, everyday semi-automatic gun works, none of this legal stuff is going to make any sense.
That is exactly right. We absolutely need a baseline. Let's just look at a standard semi-automatic fire control group.
Okay, I'm picturing the inside of the gun.
Right. So inside the lower receiver of an AR-15, you basically have three main components interacting with each other. You have the trigger, the hammer, and the disconnector.
And there's also the sear, right?
Yes, the sear, which is often just a machine surface right there on the trigger itself.
Okay, so I'm visualizing this. The trigger is obviously the part my finger touches. The hammer is the part under spring tension that's going to swing up and smack the firing pin to shoot the bullet.
Correct. So when the gun is cocked and ready to fire, that hammer is held back under heavy spring tension by the sear. The sear is basically hooked onto a little notch on the hammer.
Okay.
When you consciously pull the trigger backward with your finger, it pivots. That pivot lowers the sear, which releases the hammer. The hammer flies forward, strikes the firing pin, and bang, the gun fires.
Simple enough, one pull, one shot. But here's where I want you to clarify something for me.
Sure.
When the gun fires, the gunpowder explodes in the chamber. The gas from that explosion pushes the bullet out the front of the barrel. But it also sends pressure backward, right?
Yes, it does.
It pushes the bolt carrier group, that heavy metal slide, inside the upper part of the gun backward to eject the empty brass casing.
Exactly. And that rearward motion of the bolt carrier is actually what recocks the gun for the next shot. The bolt carrier slides forcefully back over the hammer, pushing the hammer back down against its spring tension.
But wait, if I have just fired the gun, human reaction time isn't that fast, right? My finger is probably still holding the trigger completely backward while that bolt is cycling.
Oh, almost certainly. The gun cycles in milliseconds.
So if my finger is still holding the trigger back, the sear is still lowered out of the way, why doesn't the hammer just follow the bolt carrier right back forward and shoot the gun again automatically? Why isn't every semi-automatic gun just a machine gun by default?
And that right there is the million-dollar question. And it brings us to the real unsung hero of semi-automatic firearms, the disconnector.
The disconnector. Okay, what is that?
It is a separate little hook mechanism attached to the trigger. When you hold the trigger backward after a shot, the main sear is indeed still out of the way. But because you are holding the trigger back, the disconnector is actually pivoted forward.
Okay, I'm following.
So when the bolt carrier pushes the hammer down, the disconnector catches a secondary hook on the hammer and just holds it there.
Oh, I see. So the disconnector is basically acting like a mechanical bouncer at a nightclub.
Oh, yes, exactly.
It grabs the hammer and says, "Hold on, buddy. The shooter's finger is still pulling the trigger. You can't go back up yet. You have to wait."
That is a perfect way to put it. The hammer is totally trapped by the disconnector. For you to fire the next shot, you have to physically let go of the trigger.
Okay, so I release my finger pressure.
Right. You let the trigger move forward. When you release that pressure, the disconnector pivots out of the way, dropping the hammer. But it only drops a tiny fraction of an inch because the main sear catches it again.
And that's when you hear that audible click sound, right?
Exactly. That click is the reset. Now, the whole system is back to its starting position, and you can pull the trigger again for your next shot.
So just to summarize this physical reality for everyone, pull trigger, gun fires, bolt goes back, disconnector catches the hammer, let go of the trigger, disconnector hands the hammer back to the sear, the trigger resets, pull again to fire.
Yes.
That entire mechanical sequence, pull, fire, reset, pull, that is our baseline. That is the literal definition of one function of the trigger equaling one shot.
Exactly. And now that we have that mechanical baseline locked in, we can fast forward to the fall of 2017. And this brings us to the catalyst for the modern legal war, the Route 91 Harvest Festival shooting in Las Vegas.
Right, which was an absolutely horrific tragedy, the worst mass shooting in modern American history. The shooter fired hundreds of rounds into a crowd from a hotel window.
It was devastating.
And the public very quickly learned that he had achieved that incredible sustained rate of fire by attaching devices to his semi-automatic rifles, devices called bump stocks.
Right.
And in the aftermath of that, there was immense, just crushing political pressure on the federal government to act immediately.
The political and public demand for a response was overwhelming, and that pressure fell squarely on the executive branch, specifically the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or the ATF.
But the ATF had a huge problem on their hands, didn't they?
A massive problem, because bump stocks had been on the commercial market for years, and the ATF itself had actually repeatedly issued determination letters stating that bump stocks were just firearm accessories.
They had officially put it in writing.
Yes, multiple times.
Yeah.
They had explicitly said, under federal law, these do not classify as machine guns.
But the pressure was just too high. The Trump administration basically ordered the ATF to figure out a way to ban them anyway. And so in 2018, the ATF issued a new administrative rule. They completely reversed their previous stance overnight.
They officially reclassified bump stocks as machine guns under that 1934 National Firearms Act definition.
Which is a huge deal. The real-world impact of that rule cannot be overstated.
No, it can't. Because this wasn't just some minor regulatory tweak to some paperwork. By classifying them as machine guns under the NFA, the ATF effectively banned the possession, manufacture, and sale of bump stocks on a federal level.
Overnight.
Literally overnight. You had hundreds of thousands of Americans who had purchased these pieces of plastic totally legally with a credit card at a store. And suddenly, they are holding items that the federal government is telling them are illegal, unregistered machine guns.
Carrying up to 10 years in federal prison.
Exactly. 10 years.
Which naturally immediately sparked a massive legal challenge. But to really understand the lawsuit that followed, we have to understand the physical item that was put on trial. We just talked about how a normal trigger works. So how does a bump stock actually alter that baseline?
Well, a bump stock is an external attachment. It replaces the standard stock of a semi-automatic rifle, the part that rests against your shoulder.
Okay, I'm with you.
Unlike a standard stock, which is screwed tightly to the rifle and doesn't move, a bump stock allows the front part of the firearm, the receiver, the barrel, and the trigger to actually slide backward and forward within the stock itself by a couple of inches.
Okay, let me visualize this. So the stock is pressed firmly against my shoulder, but the gun inside the stock is free to slide back and forth.
Right. And the bump stock includes this little rigid shelf for you to rest your trigger finger on. So you place the stock against your shoulder. You place your trigger finger on that rigid shelf. Your finger is stationary. It doesn't move.
Okay.
Then you take your other hand, your support hand on the front of the rifle, and you pull the whole gun forward away from your body.
Okay, wait, let me make sure I've got this. My trigger finger is completely stiff. Right. It is not pulling anything. It is just resting on a piece of plastic. By pushing the gun forward with my other hand, I am literally pushing the physical trigger of the rifle into my stationary finger.
Yes. You push the gun forward, the trigger bumps into your stiff finger, the trigger gets depressed, and the gun fires.
And when the gun fires, there is recoil.
Massive recoil. And that recoil pushes the entire firearm backward within the bump stock, away from your finger. When the gun slides backward, the trigger is physically released, which allows that internal disconnector mechanism we talked about to reset the hammer.
But I'm still applying forward pressure with my non-shooting hand.
Exactly. So the very moment the recoil energy dissipates, your forward pressure immediately slides the gun right back forward again. The trigger bumps into your stationary finger again, it gets depressed, it fires, it recoils back, it resets, it gets pushed forward, it fires.
And this happens fast.
Incredibly fast. It simulates the cyclic rate of a fully automatic weapon perfectly.
Okay, I want to introduce an analogy here just to make sure I'm grasping the real legal nuance of this.
Let's hear it.
Imagine you are holding your pointer finger completely rigid, totally stiff in the air. Now imagine I have a vibrating object, like one of those heavy old school pagers, and I just bounce that vibrating pager back and forth against your rigid finger. Your finger isn't pulling, right? Your finger isn't doing any mechanical action at all. The pager is bumping into your finger over and over again. Mechanically, the trigger of the rifle is just bouncing forward into the shooter's stationary finger over and over. The whole system is just cycling very fast.
That is a highly accurate mechanical analogy.
Yeah.
And that exact distinction, the bouncing pager, is what the entire legal war was fought over.
Because the ATF argued what?
The ATF argued in court that a single function of the trigger meant a single action from the perspective of the shooter. In their view, because the shooter only pulls forward with their support hand once and keeps their trigger finger stationary the whole time, that constitutes a single function that produces continuous fire.
But let me challenge that, because looking at the mechanics we just laid out, that sounds like a massive contradiction to how the gun actually physically works.
How so?
Well, the internal parts, the sear, the disconnector, the hammer, they are all doing their normal semi-automatic dance for every single bullet. The trigger is physically moving backward and forward inside the receiver. How can the ATF claim it's a single function just because the guy's finger is still? Isn't the Supreme Court just playing word games if they let a device shoot 800 rounds a minute and don't call it a machine gun?
And now you are hitting on the exact friction point between two entirely different philosophies of law. Purposivism versus textualism.
Okay, let's break those down.
So the purposivist approach, which Justice Sonia Sotomayor argued fiercely in her dissenting opinion later on, asks, what was the purpose of the law? The purpose of the 1934 NFA was to restrict weapons that shoot incredibly fast and cause mass devastation without requiring manual reloading.
Right. Sotomayor basically argued the duck test, right?
Yeah, exactly. If it looks like a machine gun, acts like a machine gun,
Mm.
and shoots like a machine gun, then it's a machine gun. The intent of Congress was clear to her.
Right, and it feels like common sense functionalism. Why shouldn't the ATF be able to look at the obvious intent of the device? I mean, the whole intent of a bump stock is to completely bypass the physical limitation of human finger speed to achieve automatic fire.
But, and this is a huge but, the plaintiffs in the lawsuit, and ultimately the majority of the Supreme Court, took the textualist approach.
Which means sticking purely to the text.
Yes. Textualism dictates that the law is governed by the actual text written on the page, not the presumed intent or the, vibes of the legislation. The text says a single function of the trigger. It does not say a single action by the shooter.
Okay, I see. So the textualist argument is that the trigger itself is a distinct mechanical component, and that component is functioning, meaning it is being depressed, releasing the hammer, and then physically moving forward to catch the disconnector and reset for every single round fired.
Exactly. Even though the shooter's finger is stationary, the trigger itself is functioning repeatedly. It is being bumped, released, reset, and bumped again. Therefore, mechanically speaking, the weapon is not firing more than one shot by a single function of the trigger. It is firing one shot per multiple rapid functions of the trigger.
And this philosophical and mechanical clash brings us to the climax of the bump stock saga, right? The Supreme Court showdown in Garland v. Cargill.
Yes. So this case was brought by Michael Cargill, a gun store owner down in Texas. He surrendered his bump stocks under protest and sued the government. The case wound its way through the federal appeals courts, and it created a split among the different circuits, which practically guaranteed the Supreme Court would have to weigh in.
And on June 14th, 2024, the Supreme Court finally issued a 6-3 decision, and they struck down the ATF's 2018 ban.
They did.
They looked at the vibrating pager analogy, they looked at the internal mechanics, and they said, no, this does not meet the statutory definition of a machine gun.
Justice Clarence Thomas wrote the majority opinion, and he leaned heavily into the microscopic mechanics. I mean, the opinion literally includes diagrams of the AR-15 trigger group.
Oh, wow. They put schematics right in the ruling.
Yeah, right in the text. The majority determined that a semi-automatic rifle equipped with the bump stock still requires the trigger to mechanically reset and be engaged for every single shot. The recoil might be pushing the gun back into the stationary finger rapidly, but fundamentally, the device does not fire more than one shot by a single mechanical function.
Justice Samuel Alito wrote a concurring opinion too, right? And I think his opinion really highlights the tension here perfectly.
He really did.
He essentially said, look, I get it. The Las Vegas shooting was horrific. A bump stock clearly allows a shooter to inflict the same kind of damage as a machine gun. And if Congress wants to ban them, they absolutely can. But Congress has to actually pass a law doing that.
And that is the crucial takeaway regarding American administrative law. The Cargill decision is a landmark triumph for the American legal process and the separation of powers.
It really is.
The Supreme Court ruled that the ATF exceeded its statutory authority. They affirmed a core constitutional principle. Administrative agencies like the ATF, the EPA, or any alphabet agency cannot simply rewrite laws to encompass new items just because they feel it is necessary for public safety or because of immense political pressure.
Right. They can't just look at a bump stock, apply Sotomayor's duck test, and say, well, it acts like a machine gun, so we are going to criminalize it. The executive branch enforces the law. The legislative branch writes the law.
Yes. The court said that for an item to be banned under the NFA, it must fit the literal mechanical definition passed by Congress in 1934. It'd have a massive check on executive power.
Which is so important when we are talking about criminal statutes.
Absolutely.
Yeah.
It ensures that criminal statutes, especially those carrying 10-year prison sentences, are defined strictly by elected representatives, not by unelected bureaucrats altering definitions decades later.
So to put a definitive bow on the bump stock portion of this and give our listeners the absolute federal reality as it stands today, right now in August 2026, under federal law, bump stocks are entirely legal to purchase and possess.
That is correct.
The ATF's federal ban was struck down, pure and simple.
Federally, they are not machine guns.
Hmm.
But, as we know, the evolution of firearms technology never stops. It's always advancing.
Always.
So if bump stocks were the external plastic attachment that tested the limits of the NFA, what happens when gun manufacturers realize the loophole isn't on the outside of the gun, but on the inside?
Ooh. And that brings us to the next evolution of this legal war, the force reset trigger, or the FRT. We are moving from the external stock to the internal firing mechanism.
And this is where the engineering gets incredibly sophisticated.
Mm-hmm.
A forced reset trigger is not an attachment. It is an internal mechanical component. It completely replaces the standard trigger, hammer, and sear group inside the lower receiver of the firearm.
Okay, so let's break down the mechanics of the FRT, because it is distinctly different from a bump stock. With a bump stock, the whole physical gun is sliding back and forth against your shoulder. With an FRT, the firearm itself isn't moving against you, right? The stock is completely fixed.
Right, there's no sliding. The magic is happening entirely internally.
Okay. So how does it work?
To understand the FRT, we have to go back to our earlier discussion about the bolt carrier group. Remember how the gas from the fired round pushes the bolt carrier backward to eject the casing and cock the hammer?
Yes, and we said the disconnector catches the hammer, forcing the shooter to consciously let go of the trigger to reset the system.
Right. What the force reset trigger does is eliminate the need for the shooter to consciously release their finger pressure. It entirely removes the human delay from the reset process.
Okay, how?
Instead of relying on a disconnector and a spring to hold the hammer until you let go, an FRT uses the massive mechanical energy of the bolt carrier moving rearward to forcibly push the physical trigger shoe forward, instantly resetting it against your finger.
Okay, wait, I need another analogy here to get my head around this.
Go for it.
Think of a manual revolving door. You walk up, you push the glass, you step through, the door stops. If you want to keep walking, you have to push it again. That is a standard semi-automatic trigger. One push, one step.
Right.
Now imagine an FRT as a heavily motorized revolving door. You still have to step into it and push forward, but the moment you do, a massive motor spins the door around, physically smacking you in the back and resetting the empty space in front of you instantly.
That is an excellent analogy. You still have to take the step forward into the door to start it. But the system itself is doing the heavy lifting to reset the mechanism faster than humanly possible.
Let me make sure I have the exact mechanics down. So I pull the FRT backward, the gun fires, the bolt carrier flies back. As the bolt carrier flies back, a locking bar mechanism inside the FRT interacts with the bolt. The bolt physically forces this bar down, which acts like a lever, violently shoving the trigger shoe forward.
Yes. It physically shoves the trigger forward, pushing your actual finger forward with it, regardless of how hard you were trying to pull backward.
So my finger is getting pushed forward by the mechanical force of the gun itself.
Exactly. And the moment the bolt carrier goes back forward and chambers the next round, that locking bar releases. If you are still applying rearward pressure with your finger, the trigger is pulled backward again, releasing the hammer and firing the next round.
Wow. Here is where it gets incredibly legally interesting. Because even though this internal action vastly increases the rate of fire, making it sound and perform remarkably fast, easily matching the cyclic rate of an M16, there is a crucial, undeniable distinction.
And what is that?
The trigger shoe itself is moving fully forward and fully backward for every single shot.
Yes, it perfectly aligns with the strict textualist reading of that 1934 rule. A single function of the trigger. Every single time a bullet leaves that barrel, the trigger has functioned once. It was mechanically pushed forward and was pulled backward by the shooter.
One pull, one mechanical function, one shot.
Right. Mechanically speaking, it is identical in its sequence of events to a standard semi-automatic trigger. It is just mechanically assisted to reset incredibly fast.
But despite this mechanical reality, which seems completely in line with the textualist reading of the law, The ATF took a massive aggressive stance against FRTs anyway, didn't they?
Oh, they certainly did. The ATF enforcement era for FRTs really escalated around 2021 and 2022. The ATF began treating FRTs, most notably those manufactured by a company called Rare Breed Triggers, as illegal machine guns.
They just ignored the mechanics.
They completely ignored the mechanical reality of the forced reset. They focused on the rapid rate of fire, arguing again that it simulated automatic fire.
And the stakes here were terrifying for everyday citizens. This wasn't some polite regulatory disagreement over paperwork in a courtroom. The ATF was actively executing search warrants.
Yes, they were knocking on doors.
They were seizing these internal trigger devices from lawful owners, and they were threatening these individuals with felony prosecution for possessing unregistered machine guns.
Imagine the chilling effect of that. You buy a small internal component for your rifle. You paid for it with a credit card online. It was completely legal to purchase on the day you bought it. And a year later, armed federal agents are at your door demanding you hand it over under threat of a 10-year felony conviction.
It sent shockwaves through the firearms community. I mean, many people just quietly destroyed their property out of fear.
But not everyone backed down. There was significant legal pushback. Enter Rare Breed Triggers, the manufacturer, and the National Association for Gun Rights, or NAGR. They didn't capitulate. They sued the ATF in federal court.
And their argument in court stood completely firm on the microscopic mechanical reality we just outlined.
Yes, they brought in engineering experts. They showed slow-motion video of the trigger physically moving forward and backward. They argued that an FRT fires only one round per mechanical trigger function, period.
Right, the mechanics don't lie.
Exactly. It does not matter how fast it resets, and it does not matter that the bolt carrier assists the reset. The mechanism requires a separate physical function for every single round. Therefore, it is a semi-automatic trigger, not a machine gun under the NFA.
So we have this massive clash brewing. The ATF is aggressively cracking down on FRTs, claiming they are machine guns because of how fast they shoot. And Rare Breed Triggers is fighting back, claiming the mechanics prove they are semi-automatic. This leads us perfectly into the domino effect and the ultimate federal vindication for FRTs.
It's quite a turn of events.
Because the legal destinies of bump stocks and FRTs ended up being deeply, inextricably intertwined, didn't they?
They absolutely were. And to understand what happened to save the forced reset trigger, we have to look back at the ripple effect of the Cargill decision. That 2024 Supreme Court bump stock ruling basically became the ultimate legal shield for FRTs.
Okay, let's connect those dots. How did a Supreme Court ruling about an external sliding piece of plastic save an internal metal trigger mechanism?
Because the Cargill decision firmly, at the highest judicial level in the land, established the strict textualist precedent for how the National Firearms Act must be interpreted.
Right.
The Supreme Court said definitively that a device must physically fire multiple rounds per a single mechanical function of the trigger to be a machine gun. They completely threw out the ATF's argument that rate of fire or simulated automatic fire or the shooter's intent was enough to classify something as a machine gun.
Ah, so the ATF's entire playbook for banning FRTs, which relied entirely on the idea that they shoot really fast, ergo they are machine guns, was essentially shredded by the Supreme Court in the bump stock case.
Exactly. The Supreme Court drew a hard line in the sand regarding statutory interpretation. If the trigger mechanism functions for every shot, it is not a machine gun, period. And the lower federal courts immediately took notice of this new binding precedent.
And this is where we see the dominoes start falling for the ATF.
Shortly after the Cargill decision came down in June 2024, U.S. District Judge Reed O'Connor, who was presiding over the primary FRT lawsuit, applied that exact new Supreme Court precedent to the forced reset triggers.
What did he rule?
He vacated the ATF's classification of FRTs as machine guns. He essentially looks at the ATF and said, the Supreme Court just told us exactly what the definition is, and by that mechanical standard, these FRTs do not fit it.
And that ruling sets the stage for a truly historic moment, the May 2025 DOJ settlement. I really want to dig into this because settlements of this magnitude, where a massive federal agency completely surrenders on a high-profile enforcement priority, they just feel incredibly rare. What exactly happened here?
It is a monumental settlement. On May 16, 2025, the Department of Justice officially reached a comprehensive settlement agreement with Rare Breed Triggers and the National Association for Gun Rights. And when you read the terms of this settlement, it is a total capitulation by the federal government.
They just gave up.
They recognize that the legal reality created by Cargill left them with absolutely zero ground to stand on.
Let's list the terms they agreed to, because they are incredibly strict.
Sure.
First, the DOJ agreed to drop all of its appeals regarding the FRT cases. Second, they agreed to permanently cease the classification of forced reset triggers as machine guns under federal law. Third, they agreed to end all enforcement actions and criminal investigations against owners and manufacturers of these devices.
And fourth,
Right. Fourth, and this is the one that really blows my mind regarding the administrative state, they agreed to return previously seized devices to their rightful owners.
returning seized devices is a massive admission. It is the federal government admitting, legally and practically, that they had absolutely no statutory authority to kick down doors and take that private property in the first place. It is a complete and utter reversal of their aggressive 2021 and 2022 enforcement posture.
I have to ask you, though, let me push back just a little bit.
Yeah.
Does this settlement represent a permanent, forever closing of the door on federal agencies trying to regulate these specific devices without an act of Congress? I mean, administrations change, agency directors change, political winds shift all the time. Could the ATF just try again in 5 years with a slightly different legal argument or a new memorandum?
It is a vital question. While nothing in Washington is ever permanently immune to future legislative action, this settlement, backed by the rock-solid Supreme Court precedent of Cargill, makes it exceptionally difficult for an executive agency to try this specific administrative route again.
Because the Supreme Court was so clear.
Right. The courts have spoken with absolute clarity. The definition of machine gun in the 1934 NFA is fixed to its mechanical text. Unless Congress passes a new law explicitly changing that 1934 definition to include bump stocks or FRTs, which, by the way, would require overcoming a filibuster in the Senate, the ATF's hands are legally tied.
They can't just write a new rule.
They simply cannot use the administrative rulemaking process to ban these devices under current federal law. Any future director who tried would immediately face an injunction based on Cargill.
That is a profound structural point about how our constitutional republic is supposed to work. Congress writes the laws, executive agencies enforce them, and the judiciary ensures the agencies don't color outside the lines drawn by Congress.
Exactly. It's the system working as intended.
So just to reiterate the federal reality for the listener one more time, as of right now, August 2026, forced reset triggers, just like bump stocks, are completely, unequivocally, federally legal.
That is the federal reality. But, and this is a massive but, in the American legal system, federal legality is only half the map.
Right. And that is the perfect pivot to the final major piece of this puzzle. The map of America and the incredibly complex reality of state versus federal legality. Because what all of this means for you, the listener, depends entirely on where you live. You could be listening to this in Texas, or you could be listening to this in California, and your legal reality regarding these devices is going to be vastly different.
This brings us to a core tenet of the American constitutional system. Federalism, dual sovereignty.
Right.
The Supreme Court ruling in Cargill and the subsequent DOJ settlement for FRTs only checked federal overreach. They struck down the ATS actions because the ATF violated the specific wording of the federal 1934 NFA. However, those federal rulings do absolutely nothing to override state-level legislation.
Wait, I want to make sure I understand this clearly. A state can ban something that the federal government and even the Supreme Court has explicitly said is perfectly legal to own.
Yes, exactly. Under the 10th Amendment, states possess broad police powers to regulate health, safety, and welfare within their own borders, which includes the regulation of firearms and accessories.
Okay.
Unless a state law is challenged and struck down as directly violating the Second Amendment of the U.S. Constitution, the state law stands. And remember, the Cargill case was a statutory interpretation case about the NFA, not a Second Amendment constitutional rights case.
Okay, so let's look at the map of the United States as it stands today. We have 34 legal states. In 34 states across this country, citizens can legally own, purchase, and possess both bump stocks and FRTs without any state-level restrictions whatsoever.
Yes.
If you live in one of those 34 states, you are operating entirely under the new Supreme Court precedent. You are in the clear.
Yes, in those jurisdictions, the federal standard is the only standard you have to worry about regarding the classification of these devices. But there is the other side of the coin. The legal patchwork gets incredibly treacherous when you look at the 16 restricted jurisdictions.
And this is where the legal analysis gets really deep, because we need to look at how these 16 jurisdictions are banning these devices. Their legislative approach is completely different from the federal approach we just spend an hour dissecting.
This is a critical distinction for anyone trying to navigate gun laws.
Yeah.
Think back to how much time we just spent agonizing over the precise microscopic mechanical wording of the NFA.
Single function of the trigger.
Right. It is a strict engineering definition. Well, state legislatures generally do not use engineering definitions. When you look at how these 16 jurisdictions ban bump stocks and FRTs, they rarely rely on the precise mechanics of the trigger reset or the sear. Instead, they use incredibly broad, sweeping legislative language.
Like what? Give me some examples of the language they're writing into these state bills.
You see overarching terms in state statutes like rapid-fire device or trigger activator or generic rate-of-fire enhancing bands.
Oh, wow.
Yet they are not defining the internal mechanics of the device. They are defining the end outcome of the device. If a device makes the gun shoot faster than it otherwise would, they categorize it under these broad umbrella terms and ban it.
Hold on. That raises a massive legal and practical question regarding how broadly these state laws can be interpreted.
How so?
If a state bans a rapid-fire device, where is the line? Couldn't a really light, polished, standard semi-automatic match trigger like the kind used by Olympic competitors be considered a rapid-fire device because it has less friction and allows an expert shooter to fire faster than a heavy, gritty, standard military trigger?
That's a great point.
If it enhances the rate of fire, isn't it illegal under that broad wording?
And that ambiguity is exactly the next frontier for legal challenges. Broad, outcome-based language gives state law enforcement and state prosecutors a tremendous amount of leeway to arrest people. But it also opens the door to severe constitutional challenges regarding vagueness.
Vagueness.
Yes. In American law, a statute is unconstitutionally vague if an average citizen cannot reasonably understand what conduct is prohibited. If you don't define what constitutes a rate-of-fire enhancing device, how does a citizen know if their polished trigger spring makes them a felon?
Right.
But, and this is crucial, until those specific state laws are actually challenged in court and struck down individually, they remain on the books and are strictly enforced.
Okay, to ensure our listeners are fully informed and don't accidentally become felons by crossing a state line, we absolutely must explicitly list these 16 jurisdictions where both bump stocks and FRTs are currently banned or heavily restricted by state law.
It's very important to know.
If you live in or are traveling through these areas, the federal victories of 2024 and 2025 do not protect you from state prosecution. Here is the list of restricted jurisdictions: California, Colorado, Connecticut, Delaware, Florida, Hawaii, Illinois, Maryland, Massachusetts, Minnesota, Nevada, New Jersey, New York, Oregon, Rhode Island, and Washington, D.C.
And we also have to highlight some special cases and nuances here, because the map of American federalism is never just a clean, neat picture.
Of course not.
For instance, even within states that do not have statewide bans, individual municipalities have enacted their own local ordinances. Philadelphia is a prime example of a city that aggressively enforces local restrictions on these devices, despite the state of Pennsylvania not having a statewide ban.
And what about Florida? That one really stands out on the list. The source material notes that Florida's situation regarding forced reset triggers is legally ambiguous but functionally restricted by state law. What exactly does that mean on the ground for a citizen in Florida?
Florida is a fascinating and highly illustrative case study of this exact problem. Following the tragic Parkland school shooting in 2018, the Florida legislature rushed to pass sweeping gun control legislation, which included a ban on bump stocks. But the language they used regarding rate-of-fire enhancement was incredibly broad and poorly defined mechanically.
So they didn't specifically name the FRT because FRTs didn't really exist on the market in 2018.
Precisely. While an FRT is not explicitly named in the Florida statute in the way a bump stock is, the functional interpretation by state law enforcement agencies, like the Florida Department of Law Enforcement, is that a forced reset trigger violates the spirit and the broad language of that 2018 state-level ban.
Wow.
So while a high-priced defense attorney might argue in court that the law is ambiguous and doesn't explicitly cover internal triggers, in practical everyday terms, if you possess an FRT in Florida, you are risking immediate arrest and severe state prosecution based on how they are currently interpreting their own broad statutes.
So it's not mechanically banned by name, but it is caught in the massive sloppy net of their rate of fire wording.
Yes.
That is exactly the danger of the broad language you were talking about earlier. It allows law enforcement to sweep up new technology without the legislature ever actually voting on it.
Exactly. It creates a massive chilling effect on gun owners and manufacturers without requiring the state legislature to write precise mechanical definitions that would actually hold up under intense engineering scrutiny.
Wow. Okay, we have covered an incredible amount of legal, historical, and mechanical ground today. Let's do the grand summary and distill the journey of this deep dive.
Let's go.
Think back to where we started. We traced how a single mechanical definition, a handful of words typed out on a manual typewriter in 1934 by politicians dealing with Tommy guns and mobsters, survived for nearly a century. And the exact grammar of that sentence became the ultimate shield protecting modern, highly advanced firearm accessories from federal executive overreach.
We saw how that specific rigid language, the single function of the trigger, resulted in the landmark 2024 Supreme Court ruling in Garland v. Cargill, which struck down the ATF's bump stock ban by demanding adherence to the actual text.
Right.
And we saw how the ripple effect of that SCOTUS ruling completely cornered the Department of Justice, leading to the historic 2025 settlement that secured federal legality for forced reset triggers and literally forced the federal government to return seized private property.
And as a listener, here is your main takeaway. Here is why all of this dense legal and mechanical engineering talk actually matters to your life. It is a testament to the fact that in the American constitutional system, words matter. Mechanical facts matter.
Absolutely.
An executive agency, no matter how much political pressure they are under, cannot just declare something to be true because it is politically expedient or seems like common sense. The American judicial system functions to hold federal agencies strictly to the laws passed by Congress. If the law written by Congress says A, the agency cannot arbitrarily decide to enforce B just because technology changed.
It is a profound, real-world example of the separation of powers working exactly as it was designed to work by the founders. Even when dealing with highly controversial modern technology that they couldn't have possibly imagined, the judicial system demanded that the executive branch stay in its lane and defer to the legislative branch.
Yeah. And yet, because of the dual sovereignty of federalism, the fight has entirely shifted to the state level now, with 16 states using broad, outcome-based, non-mechanical language to ban these devices anyway, which leaves me with a final provocative thought for you to mull over as we wrap up.
This is a good one.
We have seen how microscopic precision engineering defeated the federal government's broad interpretations in federal court. As firearms technology continues to evolve at a lightning pace, with CNC machining, polymer 3D printing, and digital schematics getting better and faster every single day, how will state legislatures attempt to regulate innovations that easily bypass their incredibly broad rate-of-fire definitions?
That is the ultimate legal question for the next decade.
Will the precise mechanical engineering of the 21st century eventually render these 20th century vibes-based state bans entirely unenforceable in court? Are we going to see state laws struck down on vagueness grounds because lawmakers simply cannot accurately describe the complex technology they are trying to ban without accidentally banning everything else?
It's very possible.
It brings us right back to that smoke-filled room in 1934. The lawmakers back then managed to write a definition precise enough and stubborn enough to stand the test of time and dictate Supreme Court rulings 90 years later. Can today's state lawmakers do the same? Or will modern innovation completely outpace their legislative vocabulary?
It is an ongoing, relentless battle of physics versus legislation, and the courts will be busy sorting it out for years to come.
It really is. Thank you for joining us on this deep dive into these sources. Keep asking tough questions, keep digging into the mechanical facts, and we will see you on the next deep dive.